or they will just reapply to the town. So what I'm trying to prevent are the events that occurred and how they were given a permit by the town. Does that answer your question?
Yeah. I would observe that I think the letter that you prepared and that was printed in the Penn Bay Pilot and also presented to all the board members had a certain consciousness-raising effect, if I could put it that way. I think some of the people, like the CEO, like the planning director, and like the planning board, and probably all the Board of Selectmen, probably all have learned something from reading your letter, if I could be so bold.
Well, thank you. That was partly my intention, because I didn't think people were aware of the whole
I think we've
chain of
all learned
events.
something from reading that.
So, I guess we could just go,
Yeah, we can talk about this now. So just to set the table a little bit is that when we do workshop and ordinance change, we generally do it in a dedicated time for workshops, and we have
Okay.
one scheduled for after this, which it would be appropriate to do within that function. However, we don't take action in workshops because it's just not legal for us to do it there. We generally come up with a solution in a workshop and then take the action during a regular public meeting. But because the workshop happens after this, we wouldn't be able to take action on anything we do in a workshop until next month. So that would push your timeline back. So just to make clear that, like, even if we were to workshop it tonight, we can't really vote on it tonight. We have to vote on it next month, and then there's no chance that it goes to the select board to get on the June ballot, just to make that clear.
thank you.
And even though you've made suggestions, very well phrased and everything, they have to be integrated with the land use ordinance. And our workshop has to look at the existing content and see where all that would fit in and make sure that it's consistent. That's what the workshop would do, and what everybody would think about the final product, to recommend it to the select board.
So, that's your, sorry, just to make sure I understood what you said. So you normally workshop suggested revisions to the ordinance? But I have some very specific ones that are the language that are different from ones that were, to me, it was clearly an omission of some language, just to put that back in. So sometimes you have what you call housekeeping measures. And some of these may be housekeeping, but there's just sort of different degrees of how much workshop they require, perhaps.
Right.
So some of them were just more of, they definitely needed to be discussed more. And so, like, for instance, when I say consider abutters, because I'm looking at the ordinances and I don't see myself represented there as an abutter. And I want to be sure I'm represented. So that to me was like an overall review to think about abutters in all the ordinances, or in the ones that I mentioned here. Or it may not be a complete list.
So if you'd like, we can, you've got 12 recommendations on the first 2 pages of your letter.
Right.
Or do those encapsulate all the changes that you're looking to have us discuss about to the land use ordinance?
They're a good start.
Okay, so if you'd like, and I'll ask you to help out on this since it's your proposal for changes, is to help us talk through these one by one. Is that okay?
Yeah.
Okay.
But I want to be clear, is it possible, if we're not in the workshop right now, that you could vote on some of these? Or no?
It might be
Because
the
public
case.
notice didn't happen that's a moot point.
It might be the case if they are, as you say, housekeeping. Like if it's really just a change just to make it consistent with the ordinance itself. I don't know, once it becomes substantial, there hasn't been public notice to these
I
changes.
understand, yeah.
And I think it would be hard for us to comfortably pass them tonight, in which case I would say we discuss them in workshop. But if there are any here that you say are workshopping that we can discuss right now in the public meeting and see if we can vote on it, then those would be the ones I'd want to
Okay.
talk about.
Well, we could do that, and some of my points, I would call violations of the ordinances, the existing
That's not for us, we
ordinances.
don't enforce ordinances, so. we don't-
So, some of my suggestions were to make those explicit. They may not be necessary because the ordinance says
Right,
what should be done. It
Right.
doesn't say what should not be done sometimes.
okay.
Anyway,
for example,
I'll
could
let
you-
you lead it. I'm just, wasn't sure.
Okay,
what
so
you'd
what's
want
an
me to do.
example of one that you feel like needs to be reinforced in the ordinance and is also a housekeeping measure?
Let's see. Well, I actually put quoted language in the fifth one, that section 1416 of the Shoreland zoning ordinance under administration. Just the first paragraph had added, or the code enforcement officer is appropriate. And, but it wasn't in the second paragraph in the same way, where it should have been.
So 1416, administrative item 4, the fourth item. It's down. Where's 1416? Okay, 4. Are you suggesting to, in 1416, item 4, to add the words "as appropriate"?
To add the
I'm trying
words,
to understand what the
Or the
difference
code
here
enforcement
is.
officer, comma, as appropriate. So in the first paragraph, it says, sorry,
In the first paragraph of item 4, it says, "Within 35 days of the date of receiving a written application, the planning board or code enforcement officer, as indicated in section 14, shall notify the applicant in writing, etc." And your suggestion is to, by adding "or the code enforcement officer as appropriate," but it already says "or the code enforcement officer." So is your suggestion just to change to adding "or as appropriate"?
I guess it's the third paragraph. So before the list of letters, the paragraph that begins, after the submission
Okay,
of a complete application to the planning board, the board or the code enforcement officer, as appropriate, shall approve an application or approve it with conditions if it makes, et cetera. Because it seemed to suggest that the code enforcement officer was excluded from considering the purposes of the shoreland zoning ordinance. which is what that list is right there. So without specifying that that's the code enforcement officer's job, because I presume that whoever approves permits, whether it's the planning board or the code enforcement officer, they would all be considering these criteria.
I mean, I think the way I've always read the verbiage is that the planning board doesn't issue any permits. The code enforcement officer issues all permits. So we approve an application, and that's basically a recommendation to the planning office, which includes the code enforcement officer who issues the permit. So I think you could, always infer that the code
Oh.
enforcement officer will be the one doing the final permit in all cases.
Okay,
So, this is, I think, just in regard to after the planning board approves or approves with conditions, these things happen. So we approve the application, which is what it says, but the permit's issued by the code enforcement officer. I don't know if that's
well, there's issue and there's
So you would just-
approve. Or there's
issue and a
just-
what, sorry?
There's issue
Mhm.
and there's approve. And so when you look at the table, some things are only the code enforcement officer approves, and some have to go before the planning board before they're approved.
Right, but they're always issued by the code enforcement officer. Right.
Right.
So we approve the application, and that's basically saying it meets the criteria of the ordinance, and essentially direct the code enforcement officer to issue a permit based on the application. I think that table is basically just citing, it all has to go to the code enforcement officer, and these things also have to go to the planning board. That's how I read it. I don't know if making this change changes how you perceive an applicant's process. I don't know if folks on the board feel differently from me. Jan, go ahead.
Yeah, Sarah, correct me where I go wrong. What I took away from the letter that most bothered me was that you write that the process is either unclear or it's not being followed. That you feel as an abutter that you're not being involved in this enough. I know an initial letter goes out, but I saw that you wanted to get a letter when there was things were approved, or a letter when things were disapproved. That you want-
Correction.
I'm sorry?
Abutters are not notified in this case by the town.
For the DEP permit,
The DP is separate,
okay, just to be clear.
but the town does not notify abutters.
When the town issues a permit, it's not notifying abutters because the permit's already been issued, right? So if an applicant comes to the town and wants a permit to do some work on their property, if it doesn't go to the planning board, then there is no notification to anyone.
I think there should be notification of a permit application and any decision made on that permit. Because I think that as an abutter, I have a right to know. I also have, I think abutters are resources of information when
Right.
the other people don't, aren't aware of, they don't know the land. They may not even do a site visit.
Before we take that up, I think that would be a pretty substantive change to the ordinance. Like, I know that's not a clerical change.
Right,
To
right.
change the ordinance to say that all permit applications need to be notified, that all abutters need to be notified of all permit applications is a pretty seismic change.
Yeah, I mean, if somebody.
Prior to
Somebody puts up a
approval.
wall in their bedroom, you have to notify abutters. That's a permit change.
That's true.
Yeah,
And
I
you
mean,
may
there are
make a
all-
distinction
there are
between
myriad
interiors and
permits.
stuff.
I mean, that would, as Jeff said, that would be a seismic change to try to even figure out which ones would require a butter notification. It's an interesting point, but many of them, I think, are obviously not involving the abutters.
Well, if they're obvious, then it's going to be pretty easy to identify them. But this is more about this particular situation, environmental, legal. If somebody's getting a permit to change their bathroom, I guess that's something to be considered, but that's not the degree
Can I
that
make
we're
just a
talking
couple,
about.
couple of comments here? So we're in section 1400. Before Jeff throws something at me, I'll move my microphone closer. So chapter 1400, just to remind the planning board, any change in it, and I mean anything, even if you don't think it's substantive, would have to be submitted to the state DEP for their review and approval. So even if we make a change, because we don't think it's applicable, and I'm not discounting anything Sarah's saying, we may have an opinion, but DEP may say, no, that's not accurate. So we may want to change something, but DEP may say you can't. And I'm not saying the butter notification is something that you couldn't add into it, but I will say, most of what's done in 1400 is going to require a DEP permit, which will require a butter notifications. So in 1400, if 1400 is triggered, there's a very high likelihood that the butters are going to get notified by DEP, and that's going to be before anything happens, development-wise. So,
1400 is the only section in our ordinance that is required by the state.
yes,
Okay.
yes. And I remember, and sometimes periodically we'll get a packet from the state saying you need to update 1400 in the following manners, and then we have to figure out what they mean, and then submit it back, and then they have to review it and approve it. So it's a cumbersome process. So anything in 1400 that you want to make a change, it's going to be a lengthy process, regardless. Even if you think it's not,
Yeah.
it will be lengthy.
Yeah.
So, and then I also wanted to make another point. Sarah, this is just to educate you on a tool that we have on our website, and the planning board, you may be aware of this or not, but on the screen, and I'll show you where it is on our website. But this right here, we have all of our permits through GovPilot issued, and you can see where they're located. And you can log into this and see what is going on. And you can click on them, they'll pop up, give you a work description, and this is renovation to the basement level of the building.
I didn't know it existed.
I didn't know that existed.
We've been building it. This is still relatively new. So before it was like 2 permits, and I don't know what to do, needed to make sure it works. So this right here, you can see every single permit that's issued within the town, wherever it is, and get a pretty good idea. And importantly, closed. Closed doesn't mean that they're not anything more than they've just made it through the full cycle of the permitting process. So you'll get the permit number. So this right here is the most important item for you when you call the office to get any information. So this exists for the public to use. I don't know how to get it out to the public any other way than our Civic Ready and anything else. So if you've got neighbors, share it with them.
This is 224 permits issued. Is that this year?
No,
Or
and that's
year-to-date, or-
another item that I want to clarify on like,
I mean, roughly, like, I do think there's value in notifying abutters of,
notifying abutters
Permits.
and just
like,
to.
I had it, in my property, there was a big
Yeah.
construction
Yeah.
project that happened, and
Yeah.
like, you don't know about it.
Yeah.
But I also can't even guess like how many or how few permits are issued by
There's a
code
lot of
enforcement, and it could be,
there's a lot of permits that are issued, and I will say on an administrative side, going through that process of notifying abutters for every single permit would be
It'd be
cost
massive.
inhibitive. We would not be able to pull that off without hiring a whole nother person solely dedicated to notifying people. Now, to rewind a little bit, and John Veman's in the audience, when he was on the planning board, he was very agitated that the planning board didn't notify abutters for planning board applications, and we went through that process and we beefed that up. It was just subdivision review that was notifying abutters, not commercial. So we've really ramped up the planning board side on notifying abutters so that they're well informed before anything comes up. And mail, United States Postal Service and their hiccups here in this area, that's the only issue. So we try to get it out as early as we can. Because if we don't, and as y'all heard at the last meeting, I only just got this letter. Well, we sent it out 2 weeks, in advance. You should have gotten it plenty of time. So there's things that are outside of our control, but if you stay informed with our website, if you stay on Civic Ready, you'll be informed about anything coming before planning board. And with this website, you can see any permit that's being issued, so you can see around you what's going on.
Is there a requirement for all permits that they're hung in view of the public way or whatever?
I'm pretty
Requirement?
sure we have every single permit that's on here right now.
No, I'm saying of the display of the permit on a job site.
Yes, there's a requirement of a display of permits. I don't think like plumbing is meeting that requirement, but,
Okay.
or if it needs to be displayed on that, but generally, if there's a construction going on, there's a permit that's supposed to be on display as well. So that's another item to be on the lookout for.
But this is, these are permits that have been approved and
Sure.
issued.
Mhm,
I'm
Now-
talking about applications.
So if to further drill on that a little bit, the town votes on our land use ordinance. The land use ordinance is what the town says is acceptable for the town. So as long as someone's meeting what the town has already approved, and it doesn't hit the threshold for planning board review, they can get their permit. Now, there's that 30-day window, so if you're staying on top of this, you can see, hey, there's a permit coming in, what is that? Maybe I need to know a little more, maybe I'm not comfortable with that. You have that appeal process. So that is something.
So you're relying on the Department of Environmental Protection to notify me. That's the applicant's job. When you apply for a permit with the DEP, you as the applicant are responsible for that notifying. Not the town, not the state, the applicant. The burden is on that person requesting that permit. The town could do the same. But anyway, it's a complicated situation. And I described the jeopardy it has put me in. I am really trying to address those steps and correct them. Now, the first step is applying for a DEP permit by rule. In this case, the code enforcement officer reached out to the DEP to ask them what permit this person should apply for. And when they asked that, they said he wants to return the land to a natural state. So the DEP is going on the information that the town is providing them. There's sort of, the town and the DEP are relying on each other. And then through the cracks went the reality of what's actually on this land and what the intention of removing that causeway berm is. So you apply for the DEP permit, and they ask you, because they had received letters of concern, that you were asked directly about title right and interest to this land and any possible right-of-ways or easements. And one person, without the knowledge, but the authority and the discretion permitted, evidently, by the land ordinance, was able to say, nope, I did a look-through, good to go. Oh, and by the way, can we turn it into pasture while we're at it? Would that be okay? And so the DEP staff said, apply for the permit. We'll take a look, basically. So they applied for a permit to restore a wetland. And the DEP specialist said, you'll need this permit because you'll be working in a wetland. So one of the things I'm trying to say
is this DEP permit still under appeal?
Yes,
Are you appealing it?
yes.
I don't know if we should be discussing it right now any further. I mean, the town itself is not in any appeal about it, but I was not aware that it was fully still under review by E DEP.
The appeal is pending. I mean, I can, my point is not the outcome of the appeal. My point is the process by which information is shared between the state and the town. And in this case, the state relied on the town for information. The town gave it to them. The state gives them the permit. The town permit is contingent on the state permit. So do you see this? Does anyone else see the logic here? That the town basically tells the DEP, this is what it's about, and they're like, okay, you can, apply for this type of permit.
Then where should the DEP get the information
No,
from?
I will want to correct a couple things. We did contact DEP asking what type of permit do they need to apply for in this particular area. DEP provided that information. We shared that with the applicant. We did not provide that information about what the applicant needed to apply for. That all comes from the applicant. The town does not apply on behalf of an applicant to DEP.
That's correct. The town did not fill out the application to the DEP, but the town did fill out the application to the town. That's not what the ordinance says should happen.
But still, the source of the information, or what is actually provided in the information, I mean, 10 people could look at it and say, yeah, that's what we're doing. So you disagree with that, with what they're doing. Who else should disagree? How should that disagreement be brought to the fore so that the DEP gets the, quote, assumed correct information? See, if the information came from the applicant said that's what they were doing, right? They were restoring wetlands.
They were first, the code enforcement officer was the first to approach the DEP on the applicant's behalf.
But the applicant provided the information.
The applicant completed the application for the DEP.
So what is the difference between the code enforcement officer providing the information that the applicant gave or the applicant giving the information directly? What's the difference? Same information.
I think it's the order that it happened. But, and it's not so much that the applicant did something wrong in filling out their application. It's that when the code enforcement officer, tried to clarify which permit to recommend the applicant fill out, the DEP specialist asked a very specific question to the code enforcement officer and was given assurance that everything was all set. And that's why they recommended a particular permit over another.
Well, if I could, you mentioned this very specific type of permit by rule,
Yes.
which obviates the necessity for the DEP to make a site visit.
Yes.
Because perhaps, my assumption is that if the DEP saw it, they would not agree with the applicant's description of the process or of the work that is going to be done. They might disagree.
They might.
I think that point was one that you made pretty forcefully in your letter,
Yeah, they.
that the DEP never had to come out. So everything was accomplished right here. The applicant provided the
Correct.
information, that information was fed back to the DEP, and they said, oh, well, if that's what you're doing, yeah.
Right, you're just restoring a wetland, and the DEP wants to expedite that process.
Okay, so the permit by rule, which alleviated the necessity for a DEP visit, is one of the core problems with what you're saying here. Not with what you're saying. it's one of the problems that caused the situation that you're addressing.
Yes, because it's not a problem if this is a wetland restoration project necessarily. It's that there's a conflict of different objectives for this project that were not represented to the DEP. And
Well,
so one of my points was it's that we not just rely on the state. It seems like, we make it contingent that you get that permit, and it's probably part of the state shoreline requirements anyway, right? But it doesn't remove the need for our own scrutiny, because knowing that this could be flawed, that's where we step in to protect our wetlands. Because they're not going to come and do a site visit, but we can do a site visit. And I think that wetlands are important, and that's why we have the shoreline zone in place. And I just want to be sure that any project that is near or next to a wetland gets scrutinized. And in this case, not. It didn't happen that way. And it's not just that wet land. There's also a stream, and it's Lily Pond. It's a critical, area. I mean, I said all this in my letter. That I want to amend to say work in or adjacent to wetlands requires planning board approval. To me, this was overlooked because the DP specialist confirmed this is work in a wetland. And it wasn't treated like it wasn't treated like it should have been by the code enforcement officer.
I think we do, and correct me if I'm wrong, Orion, I think we do as a board, or as a town, I should say, have discretion in our Chapter 14 Shoreland Ordinance as to which body within the town reviews what. So that table of land uses in the Shoreland Ordinance 1414, Section 1414, where it lists whether something's allowed or not allowed, I think those are hard and fast, but the group that reviews something that is allowed is up to the voters as to who we want to designate to review those things. Okay. So I think there is some ability for the town to change that table. I think it probably needs to still go to the state. I mean,
Oh, yeah, no, it would.
because it's a change.
Any change will have to get their blessing.
But it is something we can change. We can't like whittle away at the shoreline ordinance, but I don't think that sounds like what you want to do anyway.
Not at all.
You want to strengthen it. But that is something we have some latitude in. I don't know if,
But also, I think, like,
Go ahead.
overall, is the issue less specific to the shoreline ordinances and more just the ability to appeal a code enforcement decision? Because essentially, that's what it is, right?
I
No,
agree, I totally agree with that.
those are two different things. We can talk about the appeal process, and then we can talk about the authority of the code enforcement officer to act in isolation, uninformed, to permit a project that was in violation of wetland regulations. And
But if that's the case, I think the recourse would be appealing that permit
Correct.
within the town.
Right.
And it seems like, based on what you've written in the letter, it might be a relatively straightforward kind of, okay, we need to take a second look at this. But are you saying that there's not really a easy avenue to do that currently?
Not if you're not notified of permit decisions. Because the appeal window is 30 days from approval. In my case, the permit was approved on November 12th. That gave me to December 2nd to file an appeal to the town. And I didn't find out that there was a town permit until December 8th. And I didn't find out that that town permit included an erosion control plan provided by the code enforcement officer that violated state, not just state, federal wetland regulations. I found that out I got to see that plan on December 17th. So the timeliness is, I'm already behind because according to the ordinance, I missed the December 2nd window. I didn't even know that the town permit had been applied for or approved.
Well, one change that would not have us write the notification of abutters for all permits or any certain permits would be if we did change that table. If we change that table to be planning board for more activities, then there would inherently be, as
Yes.
Ryan mentioned, a notification of abutters because anything coming before us, the abutters get notified. So that
Yes.
would do that. I think
Well,
you're trying to
there's
look at it from
specific
all
numbers on
angles.
the table that I need to be addressed, but I
Right.
also just wanted to review all the ones that are code enforcement only. Because I think it's a risk when one person in one position has this authority and no oversight. I mean, there's no check, and the board is a check. So, yes, the table is where you would change it. And I had,
The only thing I'm leery about in anything that we might discuss of changing things from CEO to PB to planning board is that we are not experts on the code or perhaps even in land use, and a code enforcement officer has to be credentialed to do that work. So they know this better than we do. So I appreciate that, like, you've got a public forum, you've got townspeople able to review this, but I'm also wary that we might get hung up on something that's of a technical nature that really should be assigned to somebody who does the technical part of that job all the time. So I'm a little bit wary about, like, moving too many things into the planning board's court, not for my sake or for these guys' sake, but just as like a panel of citizens, do they have the expertise to review shoreland ordinance stuff, which is highly technical?
well, and you also have to consider, does the code enforcement officer have that expertise? And in this case, he did not.
That's a judgment. I can't comment on that.
I
but-
can.
Sure, but the code enforcement officer does have to be credentialed to do that job.
Well, he's not a, I guess it's different positions. We're talking about wetland credentials. And I didn't include this in my letter. I just ran out of time. So when we found out about the erosion control plan, and this is one of my questions, is what should you do? Because like you're saying, the zoning board has an appeal process, you could just follow it. But what do you do when the destruction is imminent? In 30 days, it's over, it would be gone and over. And that's another thing I addressed, is we don't address irreparable loss. You know, and when I tried to get the select board to take some action, they're comfortable with the risk of this loss, risk of wetland damage, and all the things I mentioned in my letter. So anyway, it was the erosion control plan that was so concerning. We didn't find out about that until mid-December. And we'd already filed the appeals. You know, it's such a complicated process when you get more information that you didn't have before, and now you have to somehow get that information submitted. Anyway, so, but someone did share with the DEP that this erosion control plan existed. And it seemed to me like they should have been shared with them before in this back and forth. But because they issued the permit, the town issues their permit, we don't go back. We should go back. Because if the town permit requires that erosion control plan, that they should just share that information. But that's a separate thing. So anyway, when they did become aware of it, they wrote to the applicant, and they said, submit a revised plan. There are problems with this. It says the plan would conflict with the erosion control standards of the department's rules. So they asked for a revised plan, and they asked to be on site to make sure that that wetland restoration went appropriately. But now that that permit has been withdrawn, I assume the plan's been withdrawn too, but I guess you could just use it again and again. I don't know. But when that was sent to the applicant, who then forwarded it to the town, the planning department. And the code enforcement officer said, or he recommended, that someone that's certified in delineating wetlands should go to the site and determine the location of the wetlands. I would have presumed the code enforcement officer would have done that before he approved the permit. So if that came before the planning board and you didn't understand this would be part of the language that needs to be clarified, what are delineated wetlands, what are not delineated wetlands. And just because a wetland is delineated or not doesn't, if it's not delineated, it doesn't exempt it from the regulations. Wetlands are wetlands. And anyway, part of, the issue of expertise is, that's important here. And you just can't presume to know that one person has that all, I guess, our code enforcement officer is certified to make an erosion control plan. And yet he made one that violated wetland regulations. So maybe we needed, just like he suggested, a certified, wetland delineation person. I guess that's more for you to figure out, to make sure you're protecting it.
I don't think you're going to find a sure thing. There are gray areas, and I think the answer lies in the people who have the most interest in a situation, like you, in this particular situation. So the DEP, the applicant has his own desires with respect to this. The code enforcement officer may look at it and say, looks okay. 5 other people who are not intimately involved with it may say, looks okay. But it takes someone who has an interest to point out that, well, it's not okay, and here's why it's not okay. And that's an abutter or somebody else who is interested in a particular project. So I'm agreeing with you. The notification to the abutters is a problem that needs to be somehow resolved in important cases, at least.
Another thing that occurs to me that some towns in Maine and in the U.S. have something called a pre-application neighborhood meeting. And since we've eliminated pre-application, it's just something to consider. It's
Well, we
a
have
way
them.
for people
We
to.
have them with the planning board. We have pre-application meetings.
It's going to get
But,
removed.
you know, to do that for
No, it's
every
not.
single project in the town, we would be doing this 60 hours a week.
Yeah. No, I think you may be misunderstanding our subdivision review, that ordinance that we changed doesn't remove the pre-application review. It removes the is it preliminary review. So it's the second meeting that it removes. The first one still exists, and the last one still exists, but the one in the middle doesn't. That's the one we
Okay.
took out.
Okay.
But, you know, another part of this, there is no technical, in this particular case, there is no technical easement across the property, right?
Well, it's a very complicated legal
Well,
issue.
I understand, but there's no technical easement. And is it formally designated an historical structure? Or just a lot of people think of it that way?
It's under review for.
It's under what?
It's under review to be determined eligible to be listed on the National Historic
Okay,
Register.
So that's a gray area right there, you see? And
Yeah.
it takes somebody who has an intimate caring about something to say, wait a minute, yes, it's not there yet, but it's under review, and don't cart it away in dump trucks before the final decision, right?
Or it takes a shoreland ordinance that actually has that purpose in it. I am an abutter. I'm in a special situation to be an abutter because my land is threatened by this project. And that makes it an urgent thing, but it's not just my land. You know, I'm not here, you know, this is the public interest in this, in Lily Pond and our wetlands, and this is why we have a comprehensive plan and an ordinance. I mean, my knowledge of it, is that what you're saying? Like, I just have the local knowledge of it?
I'm saying that no matter what process you devise, things can slip through the holes if people are not intimately familiar with or intimately caring about something. They'd say, yeah, do it, who cares? But somebody maybe does care, and that person who cares should have access to knowledge about the project
Yes.
before it's done irreparably.
Prior,
I mean, if
yeah.
in your desire for there to be a notification process for permits, are you limiting that to wetlands, shoreland, or any kind of permit? So just to like narrow that down, like where would you find that notification threshold?
I hadn't figured that out
Okay.
specifically, but definitely things that are environmentally and legally sensitive.
And
or
would you see
complicated.
there being a process in that notification? Generally, the notifications that we do are for things that have to go to a public meeting for, planning board approval. butters are notified because it's going to come up, because there is a chance for the public to speak out on it. But generally, the public doesn't have a chance to speak out on anyone's permit. The permit is publicly available, but there's not a public process for that. Are you thinking there should be a public process for that? Because otherwise, you're still in the same position where you may know about it, but you don't get to say no or voice any kind of opinion on it in a public forum.
Well, I think that those pre-application neighborhood meetings are a chance just for people to have those conversations and bring up those issues. And I just wasn't given that opportunity. And this was a done deal. And the land under threat, and you know, the appeal process, it favors the project. It's hard to, and you're just minding your own business, and all of a sudden something's happening and you have to react to it. And you don't, and before you even understand the consequences of this, I mean, look at this in this case. I learned about it on November 4th. I had no idea that they were going to fill the wetland until, you know, mid-December. So it evolves. The knowledge evolves. So it's done. That's why it just seems like we just have to consider the context of these projects, and make sure that everyone is represented. And that's why I pointed out, like, if you want to apply for a permit, in this case, it's like $105. In this case, you got the CEO to do it for you. The CEO even provided the erosion control plan. But, you know,
Your opinion is that town officials should not be helping people? I see the gentleman is nodding yes.
helping people?
Helping people, yes.
Well, it's your job to help people. But
that
you
is
should
our
not
job, is to help
have
people.
an interest in the project. That's a conflict of interest.
Why would you think the CEO has a conflict of interest?
Can I stop us for a minute? Ryan, you said there's a case related to this,
There's currently a DEP appeal that
and I don't know if we should,
I'm going to encourage y'all not to talk about a specific project.
Yeah,
If
I don't
there's-
want to talk about this.
I don't think we should get into
If there's something in this letter
personalities,
that's
Okay.
needing to be addressed, let's address it, but any specific project, especially anything under a current appeal, probably.
Thanks, Peter.
But do you understand conflict of interest? Do you understand the liability to the town if someone's actually contributing material to the project, plans, actually filling out an application for someone? When the ordinance says you had to fill it out yourself.
Well, I think, I mean, what I would ask you, Sarah, is to, like, actually specifically define the changes, like, substitute this phrase for this phrase, or take out this section and replace with this section. Not because we want to be absolved from doing that work, but because it really gets to what you're trying to do. I think, you know, when I read through these lists, I was like, wow, that's a tough list. I mean, to have us try to work through. It's going to take more than one night for sure.
Yeah.
But things like, you know, preventing, I don't remember what this says. Oh yeah, make it explicit the code enforcement officer be prohibited from preparing permit applications and supplementary materials for applicants. Now, when the code enforcement officer passes a sheet of paper across a desk and it's got lines for the applicant to fill out, that's them helping or assisting them in that application. Like, you could, as a lawyer, take this to an extreme position where you can sue the town because the town helped somebody do something contrary to the ordinance. So it's like, it really,
little bit extreme.
It is
Do
extreme.
you understand? This is very different from what you're
And
saying.
the town has experienced lawsuits from, I think, positions that are kind of extreme. So that's where I just like, I don't want it to be open to the extreme interpretation. So really like a close reading of these changes, because they do become essentially the town's regulations, is, I think, very helpful for us, for the select board, for town voters to vote on, so that
So
it's
you
not
want it
open
to
to everything.
specify and say, completing an application.
Whatever
or
the phrasing
providing
is, but it's like, you
the
know, all
required
permits,
parts.
all permits you need a butter notifications, like we took it to an extreme, but that's what you could do with this, is that somebody puts up a wall in their bathroom, all their butters get to know about it, and they get to comment on it, and it's like, that seems, nobody's gonna go for that. Like, I can just with confidence say that that's not gonna pass. So if
Well,
we.
that's understandable.
If we define it to shoreland work or work in wetlands must go through this process of notification, then that's much better than
Right,
permits.
and I did do that.
Right, but in one of your bullet points, it just says permits, and like, that's all permits, as far as I read it. So that's why I'm trying to get you to, like, help us with what specific things should we be looking at, rather than in general, because then we have to interpret what does Sarah actually want us to change here, and we're not intimately familiar with what the motivation is. But I do know, I mean, I think the most important part is that there's more information that should be made available to people who have an interest in the project, and not just an interest like a financial interest, but live next door to it. They should be made aware of it prior to it happening. And so then the what of what's happening is something we need to hone in on, and the process by which abutters can be aware of that thing, we need to hone in on it. It'll take us some time to do that. I don't think we'll be able to get through that tonight. I mean, we're, I think, coming up to speed on it,
Yeah.
but I don't think we're going to make that leap very quickly. It's just, that's,
It's not really
The
an agenda
slowness.
item, so.
Yeah.
We really can't.
right, that's also the slowness of this process of writing laws takes time, like, I've been trying to get some changes to the ordinance that through for years, and we're gonna work on that tonight.
I understand that. This is a beginning, but I need protection from this recurring. That's what I'm asking for.
I think we all hear that. I think
So now,
people are very sympathetic
now,
to the concern too.
when this happens again, what do I do?
If you get an abutter notice, it may be on your side that, not you being the general person, gets an abutter notice, that a permit has been applied for. That should set off on your to-do list. Check and see what happens with this permit. Go to the hearing, see what happens with the permit. Do my own investigation, contact the DEP to find out whether or not all the wetland things. There is some onus on the citizen, on the abutter, to, if they've been told that there is something happening that may affect them, the onus is then on them to be aware of it and to follow up on it. We make all the hearings are public, and there's notification that goes out ahead of time. It's on the town calendar. We have now a map that shows all the permits.
And it should work that way. But in this case, I will not get notified. There will be no hearing. It'll be a decision made by the code enforcement officer all over again. And I guess for me to be aware of it, I will have to call the planning office every day. And I can't even be guaranteed that my call will be returned.
If that is in fact the case, then we need to design, with your help, a better process for notifying people. Maybe permits ought to be listed publicly when they're being approved. I don't know. Give us the ideas to help. I agree with you that the people need to be informed of everything that goes on in town. It's one of the values of a small town, is that we do have that option of letting people know about things. But we need help to figure out what the process is to let you know.
Ryan, are all permits publicly available?
Yeah.
If someone comes to the town office and they want to see if their neighbor has pulled a permit from some work they see
Yeah,
they
yeah,
already
yeah.
have, it's,
Yeah,
they can
that's
see the
fine.
permit.
It's all,
Yeah, that happens. And generally, people just shoot an email and we send them the email, the digital permit anyway, so,
The application or the permit?
the permit,
The approved permit?
yes.
It's too late.
Well, I mean, if an application isn't approved, then why should it be shown to anyone? Like, people can apply for permits and they're all wrong, and the code enforcement says, no, you can't have a permit for this. Why should the town notify people that
Right.
there wasn't an
it's not,
approved
once a
permit?
permit has been issued, it is not too late.
Right.
It is a simple matter to have an attorney get an injunction to prevent the construction from happening. A judge will
I
give it
think
to you.
the issue is the potential that the 30 days could lapse without the abutters knowing. And I think that that's a valid one. I don't,
Could you move a little bit away from the microphone?
Oh, sorry.
Yeah, all I'm hearing is you breathing.
Sorry.
I think that's a larger issue that needs to be discussed by the town to see what their resources are. I mean, if you want my opinion, if there was like investing in software that could actually just shoot out an email to people if, you know, if a permit triggers certain things like land moving or something, noise or something, in this case, you know, erosion, shoreline, if there was some program that could shoot out emails to butters, that would be great. But I don't know if it exists, or
Right,
like we can't be sending letters out to everyone
right.
for all permits. It would be
Right.
crazy. But I do think there is, like, yeah, I mean, without just having your ear to the ground, I think there's a lot of cases where the 30 days could lapse without
So-
someone knowing.
Orion, if a permit was issued in the new GovReady, is GovReady, is that what it's called? GovPilot software, Civic Ready GovPilot. Does that go on there as soon as the permit is issued?
Yes.
Okay, and could somebody look at that data in sort of a sequential view of when permits were issued? Or is it just through a map?
It's just through a map right now. It's just a map.
Okay,
Yeah, I mean, it's too, you know, it's so cumbersome to
yeah.
be proactively
Yeah.
looking for permits.
For
But it's
something you don't
also
know
like-
exists.
Right,
I mean, in
exactly.
Sarah's case, it's like, well, why should I have to ask every 5 minutes to see if something exists?
Right.
And what if I discover something that is an error? What am I supposed to do?
Well, that would then, I think, be a pretty clear trigger for the Board of Appeals.
If a permit is issued,
I mean,
can work begin on it immediately?
Yes. And this is,
So-
this is the risk for developers. Within that 30-day period, you could do all this work and then it'd be wrong, and then the appeal happens, and then you gotta put it all back.
But if you can't put it all back,
Well, there might be a court order that you have to put it back in whatever, or to the closest degree.
what does that count for the applicant person appealing? The appeal process is laborious
Yes.
and time consuming, so.
And the burden's on me.
I think,
But
I think
I
that,
think we need to go back. One thing that we didn't address that I really wanted to was, and you added this wasn't on the agenda, but you added it in December. And to my understanding, that was not a public comment item, was that it was decided by the planning office that this project was an earthwork project. But to me, this is a permanent structure. And that's language that the DEP uses, it's language that the Historic Commission uses. It should be understandable. This was a man-made stone causeway. That's a structure. And therefore, the shoreline ordinance should have applied to it.
I mean, this, I think, conversation is getting into zoning board of appeals sort of review. We haven't seen an application, we haven't seen a permit application, we
Right,
haven't seen
yeah,
a land use application, so we can't really comment on any of the specifics of that project.
Well,
Like,
you commented on it in December.
I commented on, at the select board meeting, the process that we were hearing did not happen. So just to basically say that the planning board has not reviewed an application for something that seems to be taking place in the shoreline zone, that perhaps could be part of a larger development which would go through the planning board. And if this thing is an enabling project for something that's coming later, and that something that's coming later perhaps wants to seek planning board approval, then the applicant should be aware that they may be putting themselves in a disservice by doing something that's disruptive to folks like yourselves, that's contentious, where you want our approval for something beyond what the ordinance by right allows them to do. So if they were asking to build something that we had jurisdiction to control the number of units of, say, housing on there, then we would be coming at it saying, you know, you already kind of like are not being, I don't know, doing things that your abutters are favoring. And so why should we provide you additional building opportunity here? So that was my caution to the applicant. And it was also my query with the town of, shouldn't this be something that the planning board should review? And it may be maybe a difference of interpretation on the shoreland.
And that's what I want to
Right,
make
but I didn't
clear.
see an application, so I don't know. It's
And
kind
you
of.
won't see an
And
application.
I won't see an application because it didn't come to us.
Right. Because someone decided you shouldn't see it.
But just like you, I can't stand in the planning board office, the director of planning's office, and see everybody that comes in and see how they're deciding what goes to the planning board and what doesn't. So I can't be on that.
Right. But, I mean,
That's what we pay Orion and his colleagues to do.
and I see a flaw in that. Because here I am.
Okay, well, I think we've spent an hour and 15 minutes on this. I don't know if we're going to get much farther on it, but I think we all understand the nature of the changes that you're looking to. Again, I would request that if you have very specific changes that you'd like us to review, that we come back and workshop those. Again, it's not going to happen for June, and that's just the timeline, but it could happen for November, and those are the kinds of changes we're discussing up until July, August.
And just to reiterate, because I didn't show exactly where you can find this interactive map. So if you go to our website, the Planning, Community, and Economic Development and Codes, and then there's the digital interactive map under the helpful documents. That will take you to this map, of which you will trigger on the permits, and then they will all show up. So you can zoom into your parcel, you can see the abutters, you can see if there's any permits that have been issued.
And what is the difference between issued and closed again? They seem to
Issued
be
and
almost the
closed,
same.
right now, the closed is just, it's done its complete cycle through it, and it's no longer a thing we need to pay attention to. But it was
Okay. So
officially
it's-
issued. Yeah.
What's the distinction for a resident of Rockport if they're just looking at this?
Closed is more than likely it's past the 30 days. It's definitely like a done project, as in it's built. It's got its C of O and done. So another item we're kind of looking at this is not the year, so it's more than the year. So there's probably another way to display this. So if you see it and you want feedback on it, by all means, reach out. We can kind of tweak it a little bit. It's a little confined in what we can do, but there are some ways to make it better.
Okay.
Okay.
Anything else, Sarah?
Well, I would like to know what I did wrong, because when I became aware of this, I didn't know what to do. And it seemed to me that from what was being presented by the planning department, it was contrary to just like I wrote in my letter, this was a conflict, and not just a conflict, a violation. And so I thought I had to go past the planning department to get some sort of recourse. I did follow the appeal process that was available to me. But the urgency of it meant that I needed to do more, because I didn't want the stream to get trenched, much less who knows what would happen to the wetland. So I went to the select board, but their understanding was that was for the planning board, that was for the planning department. It didn't matter because, we have our ordinances, we have our processes. There is, everything was done by the book. And I don't have any recourse except to appeal to the zoning board. And I guess, just get involved in a really lengthy and expensive process when I was just minding my own business. I didn't ask for this. This happened. There were errors made. That's not an opinion necessarily. And so now I guess, I will try to write very, very specific request, and I guess come back and try to strengthen the ordinances so it doesn't happen again. But in the meantime, it there's nothing to keep it from happening again.
Yeah, I mean, our role is pretty limited. Even less so than the select board, we can basically act on applications. We can modify the ordinance or recommend to modify the ordinance. We can't do it on our own. And that, like I said, takes time. So as to what your process is, the only thing I know is that you go through the zoning board of appeals for something that is something you disagree with, and we really have no say in any of that. So, as for us, I think we'll look at the ordinance, but we really have no application to look at, so that's all we can do. Anyone else have any thoughts?
No, I would just simply encourage you to, as Jeff said, to give us a list that is more specific as to what specific things should be changed and in what direction. And then we can run a workshop, we can do it. November is going to be in November, whether we do something or we don't do something, let's do something.
Well, they've already given you some specifics,
Yes?
and I will, clarify so it's not crazy.
Mm-hmm.
But in the meantime, Orion, can I have an assurance that if I call or write to the office, I will get a reply?
Yes, and actually, I would like to make a comment that had you called us the moment you got a notification from DEP, we would have talked to you about it, but it went around, so I got third-party interpretations of a concern that someone had about it, so I didn't have a way to get in touch with you about it.
I was on those emails.
And then nothing was asked about what can be done, so we will point you to the appeal process.
All right.
appointed many people to these.
That's,
we should move
that's
on.
true.
We should move on to our agenda items.
And is this, so we're done? Is there going to be any workshopping this more tonight, or?
We're going to have workshops until this beginning or the end of the summer, so we can add it into our workshop agendas, but we're not going to take up things in our regular meeting until we have an approved text from our workshop process. So
What?
we can't really vote on anything in a workshop, and we can't really work on ordinance changes in a public meeting just because of its inefficiency.
see.
So it's much more efficient for us to work on it in a workshop.
Oh, I see. And
And
then
then-
you're
and
going to
then bring
make
it to a
a
meeting.
text, you said? Approved text, is that what
We
you said?
approve, we make a recommendation to the select board once we have a text that we all agree with, and that's what we can vote on in the public meeting. So I'm sorry these things take so long, that's just, I didn't invent the process, that's just how it goes. So we'll continue to discuss it in our workshops.
Well, thank you. Thank all of you.
Thanks, Sarah.
Thank you.
Okay, so the item on our, oh, yes, I can, yes, do another public comment on an agenda item. Yeah,
I won't be long.
okay,
3
so I get to wait.
minutes, Maybe 7
Okay.
minutes. I'm Linda Clancy, Rockport resident, and I live on Main Street. And Sarah is a catalyst because as I was writing the pre-meeting story of your meeting tonight, I saw the adjourn to workshop ordinance amendments. And I thought, oh, are they going to talk about Sarah's issue? And then I thought, well, I'll ask Orion. And I asked Orion, and he said, no, we're talking about November. And so that triggered in me a memory that I wish I hadn't forgotten. But back in 2024, there was the item before the voters, I guess it was probably June 2025, amendments, and one of them was the high elevation performance standard, section 900. And now I'm going to go back in history to 2003, when I was on the comp plan committee, and Jeffrey was on the comp plan committee too. So Jeff, if I say something wrong, you can just shout out and correct me. But there was a lot of conversation in 2003 about how Rockport, we really didn't want it to be, the hillsides didn't want it developed like the Caribbean or California, where you had the, the houses stacked up on top of each other. And when you drive Old County Road, for example, in the early morning, and you look at you could almost see the division of the town line between Rockland and Rockport with Dodge's Mountain. So when I saw in 2025, I guess it was, or 2024, the Section 900, I emailed Orion, and I also saw John in Beauchamp Point, and I mentioned it to him then because, John, you were in the planning board, I think, at that point. And I was writing then an article about the proposed land use ordinance amendments, and I said, would you tell me the reasoning behind removing the elevation standards from the ordinance? And Orion, you wrote back with a really in-depth email, and this was February 13th, 2024. So the portions you have in your email were a part of the 908.3 special district standards. As currently written, they all play a part of each other. But they weren't, these land use ordinance items were not carried over correctly in yours. I don't know if this is ringing a bell or not.
Well, you said 909, I was like 909, 908.
Yeah, 908. And then you continued, you said Pleasant Mountain right now is primarily owned by Maine Water and therefore undevelopable for water quality purposes. Further, this is within the Mirror Lake Grassy Pond overlay, serious standards to adhere to for development. Summit is 1,027 feet. With current ordinance, development could take place from 750 feet to 960 feet, 67 feet from the top. With the strict development standards to adhere to, it isn't in the developer's interest. The septic system design standards would also be a hurdle in this area to develop. Spruce Mountain, There is no official west or east peak on the zoning maps of years past and fall within the same zone district overlay as Pleasant Mountain. From the elevations on the contours map and the location where Spruce Mountain is located, the summit is incorrect and should be 955 feet. Due to the incorrect wording, the review would not be able to uphold the standards of Spruce Mountain because there's no official marking of the location of west and east. Ragged Mountain, well, we know about Ragged Mountain. But the current ordinance would allow for development from 500 feet all the way up to 1,100 feet. So practically allowing for development all the way to the top. Spring Mountain is already developed. I'm not sure if that is under current ordinance or not, because we've changed we've amended lot sizes subsequent, I think, over the last couple of years.
It was already developed.
And then Dodge's Ridge, and you wrote, I assuming this is close to Dodge Mountain in Rockland, since there isn't anything on the zoning map of years past for this location, nor is a Google search of any help for locating this. It would be hard to uphold this in a review process, given it is not listed on the zoning map or the previous zoning map. However, if this is on the Rockport side of Dodge Mountain, then it falls within the 914 overlay. Further, if this is the location, then structures could still be built on the Rockport side of the mountain, for they fall within this range of 400 to 484 feet, according to the contour map. So, with all that said, I said, well, then what voters voted on in 2004 in the comp plan was sort of the vision of how we're trying to keep our hills, and the hills, we do have a lot of hills, and I printed out a map of what's protected in the mid-coast area, and Rockport has a lot of hills that do not have land trusts or land and easements or conservation. In other words, it's can be developed. The hills of Rockport can be developed. So, Ryan, I don't know if you remember, and tell me if I misrepresent this, but when I expressed my concern, you said, well, we can address it, these concerns, development, performance standards, as in the next round. Well, then I subsequently forgot, and here we are 2 years later, and I've been wanting to come to the planning board for a few years to bring it up, because it was in the comp plan in 2004, and I know we have a new comp plan, I realize that, and I'm not trying to dig up the old comp plan, but the language, and we're always evolving, so I understand that, but the language we used a lot in the comp plan in 2004 was, it was, we concentrated a lot on natural beauty, on, scenic values, view sheds, and habitat. And our priorities have changed now to focus a lot on housing, and we have an emphasis on growth in Rockport. And I really hope, and this is where it falls into your purview, and I don't, unlike Sarah, my mind is not precise, and I'm not up to crafting ordinances for you all, but I want to encourage you all to, as you move into the November amendments, to think about those high elevation performance standards, which in 2004 we said should consider elements such as building colors, materials, vegetation, and siting for buildings constructed at high elevations, that they should blend into the landscape to minimize their visibility. And it is further recommended that the highest point of any structure be built at least 50 to 100 vertical feet below all mountaintops or ridge lines in the high elevation areas except Dodge's Ridge. Don't ask me why. I think we had Dodge's Ridge exempted. Jeffrey, tell me if I'm wrong. Because there was a landowner there who objected, which is a lousy way of writing policy or visions for the town. And then I just wanted to emphasize the habitat part of this, because another thing that triggered me, because I do watch your meetings, you guys, I watch your meetings. And last time you met, it was the map, and I noticed this one lot close to the town line, and I don't know if that's who owns that lot, but you combined it for, I forgot which zone, which is the yellow zone. Anyhow, there's a lot of habitat in that area, and then I got worried because, you know, I live on Main Street and I've been there since '93, and the neighbors, we all watch the animals, and I think all of us do that in Rockport, right? We pay attention to who's in our backyard, who's in our natural ecology. What are we doing as a town within our ordinances to be cognizant of the habitat? And we did put in the 2004 comp plan that we should map the habitat, because I know, you know, old timers have told me, well, yeah, Bear Mountain, which is, what's the name of that subdivision down there? Down near Home Depot, high up. Come on, that's Bear Mountain. Anyhow, it's named Bear Mountain because the bear used to come through, and they used to come through the wetlands across the street from where I live. So all of that is part of what Rockport is. So I ask you, I request of you, and I encourage you that as you move into shaping amendments, that you think about the performance standards for the hills, but you also explore the idea of what we're doing for habitat.
Okay.
That's my spiel. Thank you very much.
Thank you, Linda. Okay, any other public comments? All right, on our agenda, approving the minutes from last month's meeting. Everyone had a chance to review it, so are there any changes that you all would like to discuss on the minutes? Jan?
No.
Peter, you weren't here. Rob, changes? Okay. I'd like to offer a motion.
I move that we approve the minutes as amended from last month.
Okay, thank you, Tom.
Second.
Thank you, Jan. Any further discussion? All those in favor? 1, 2, 3, 4. Abstaining, Peter. 4, 0, 1 abstention. Next are the 2 findings of facts and conclusions of law for the 2 applications that we saw. I should clarify, one was an application and one was a waiver.
Correct.
Last month. So first was the waiver request from Chen Family Properties, and I think we've all had a chance to review these minutes. Findings of facts. Were there any highlighted changes that anyone would like to discuss, or
Just there were
edits
like
they made?
some big changes. It was written, they were written down like close to the, well, not on that one, on the next one.
on the next
Well, even
document?
there was like conflict of interest that could be pushed down.
Oh, you mean
yeah.
formatting?
Formatting will be
Yeah,
fixed.
just a,
Yeah. There's a difference
I
in
guess it-
formatting online versus what gets
Yeah.
spit out, so.
oh,
Bear
okay.
that.
Generalized.
I know, I've taken issue with that too.
Surprised that we needed to,
Do findings of facts.
right.
Yeah. This is
Is
erring
that-
on the side of caution.
Okay.
That's all this
Yeah.
is.
Yeah, that's what I figured. Okay, any more discussion on this, or is there a motion? Discussion, motion, anyone?
Oh, I move to approve the findings of facts.
Thank you, Rob. Is there a second?
I'll second it.
Okay, thank you, Tom. Any further discussion? All those in favor? 4, 0, 1 abstention. Thank you.
And then just to recap, we changed the bylaws to allow you to automatically sign, so we don't
Yeah.
have to.
If it's approved,
Make that
I
motion.
can sign.
Yep.
We don't need to get approval to me to sign it. Okay, findings of facts and conclusions of law on the pier application, on, what was the name of the road?
45 Pandy Lane.
Pandian Lane. Can you just show comments? Comments are shown. I didn't have any major comments. I don't know if anyone else did. No? No. Okay. Any motion to approve these?
Move, we accept the findings of fact on the pure.
Thank you, Jan.
I'll second it.
Thank you, Tom. Any further discussion? All those in favor? 4 and 1 abstention. Thank you. Okay, and the last item on our agenda, was, you bring up the agenda? I think it was comp plan. Yeah, recurring items, comprehensive plan. Are there any updates you wanted to provide, Orion, to comprehensive?
No,
plan?
we're making good progress right now. Since we're,
We issued our, work, what's it called?
work plan.
Work plan last month,
Mhm.
so that's
Mhm.
part of the comp plan
That's what we worked on.
acknowledgement, yeah,
Uh-huh.
of what we're gonna work on.
Yep. So y'all are good, just in terms of like the comp plan itself, I've been waiting on the budget cycle. Last night, it kind of concluded, I mean, they made the recommendations to the select board, so now I can send, the applicable strategies that relate to departments and send that off to them and ask them how they're gonna start working on it. But that's the only update to really talk about. So I believe, John, y'all, I wasn't at the last select board meeting, y'all approved the work plan for the planning board. Do you remember? If not, I'll pull it, but.
We approved the Economic Development Committee. If you gave us the planning board, it was approved.
Okay, yeah.
Especially, yes,
Yep.
because it included the, the comp plan
Yeah.
detail.
Okay.
We kicked back the parks.
Yeah.
and one other one. Sorry, I should know that.
No, that's okay. I jumped it on you, so yeah,
Okay.
we'll have that. I'll pull it. I'll make sure it's circulated to everybody and up in the SharePoint.
Okay.
Yep.
All right, I just had one more thing, just a public service announcement. If anyone on the board needs to take a bio break during the meeting, we should technically stop the meeting, and we can all share in the bio break, but it means there's a risk that if not everybody is here to hear something that an applicant says, that we run the risk of not being, or perceived to be not being aware of everything that was said if you're out of the room. So just raise your hand, offer a motion to take a bio break, and we can do it, which is what we're gonna do right after this. Go
Yeah,
ahead,
that's
Jeff.
what I was gonna do, is
Yes.
make a motion, yes.
Yes. Okay.
The
no,
other,
now we-
possibility would
I think
be
we
to
need
pipe
to, should be
sound into
specific
the
about
men's room.
what.
Yeah.
Okay.
Specific,
about what
specific
ex-
bio break, or snack break,
We
whatever.
can just adjourn to the workshop and then we can do that.
Yeah. So is there a motion to adjourn? Thank you,
Second.
Peter. Thank you, Jan. All those in favor? All. Okay, 5-0. Okay, this meeting is adjourned at 7:17 PM. We will be having a workshop, ordinance changes, workshop to discuss ordinance changes. This is a public meeting, but the recording will end here. For future meetings, the public is certainly welcome to attend them. We make no secret of it. It's just a less formal environment for us to operate under. Thank you all.